how we're going to do today is Chris is going to talk primarily to the slides. I might chip in as required, and then we'll hop into Q&A. And so Slido is flying. We've got a lot of questions on notice, and there will be opportunity from the floor as well. So I think probably part of this is probably setting the parameters for a lot of the things that you probably want to hear about today. And I think one of the big things for me that always comes up in these seminars is that what the law is never going to be able to do is regulate human behaviour. So as much as we've got legislation about acting reasonably and all that sort of stuff, there's still a hell of a lot of grey in there. So probably what we tend to do with these things is get a bit more practical in terms of trying to stop having to talk to me, having to finish up in Chris's office, recognising sometimes though that there's no choice about those things. So, Chris?
Thanks very much, Frank. Thanks everybody for coming. As Frank indicated, we'll try and step through this presentation relatively quickly. I do tend to talk fast, but if you do miss something, please let me know. As Frank has said, we would prefer to leave more time for questions at the end anyway. So sorry, just a bit of a disclaimer first. I routinely do these kinds of events with a whole range of body corporate management companies, legal firms and peak bodies, but just a disclaimer, my office is here for everybody. So we don't advocate for the rights of owners or committees or managers, we actually provide services for everyone. So what we'll get from today, as Frank said, practical tips about ways to actually avoid disputes. So my office is in the business of dispute resolution, but we're also interested in the idea of dispute prevention. If you do need to come to my office, how might you get the outcome that you want? And I'll talk a little bit, not too much, about dispute resolution as it happens through my office. Some of you might already be quite familiar with that. In particular, I'm going to talk about conciliation as a way of resolving dispute, a very, very small amount of discussion on codes of conduct, and of course, Q&A. I'm going to kick off with the practical stuff. So, taking the hot air out of dispute resolution, what are some of the tips? Frank and I have done a couple of these kinds of events over the past 12 to 18 months, and we've gone over a few of these tips. They're tried and true. Sometimes they sound a little simplistic, but sometimes it pays to remember those simple black and white tips. So, the first one, set the boundaries early. So if you're on a committee or you're an owner, set the boundaries early about the expectations of your engagement with each other. And within that, one of the tips I always like to give, try and de-identify, and I've invented a second word there, de-emotivize. What I mean by that, if, for example, you are on the committee, create an email address that is specific for your work on the committee. So, John Smith, committee@gmail.com. Make it quite separate from your day-to-day email address. That serves two purposes. First of all, it creates distance between you and the body corporate business, so you're creating a clear line there between this is my life, this is body corporate business. Secondly, you need to bear in mind that any email in which body corporate business is discussed is more than likely going to be a body corporate record, which is then going to be available to be searched by pretty much anybody involved with that scheme from now into the future. You really don't want to be saying anything there that you can't take back after the event. As I said, use some generic contact details. Give a warning, set some boundaries. So if there's some interaction, be it an owner, be it a committee member, or indeed body corporate manager engaging with a client, give a warning, that's not on. What you just said then, not right, let's stop it right there, nip it in the bud. As somebody who's recently acquired a dog, I am learning that there's no point in correcting after the event, you have to correct at the event. And then after that, you put restrictions in place. So there is the ability for committees and for owners to restrict the ways in which communication happens. So, and there is a particular adjudicator's order which I speak to at these kinds of events, in which an adjudicator has made orders about the way in which an owner is allowed to communicate with the committee, to the point where that person is only allowed to communicate once per week by registered post. So that kind of restriction can occur. Frank, I think you want to say something about that one?
Well, it's more another macro thing, but really ties in with this. In these things, time is usually your friend. And I had lunch with someone the other day who had just finished a committee meeting, chairperson's former director of listed companies and all that sort of stuff, so relatively highfalutin, older. And what he said, which has resonated to me a lot, is that what email has caused us to lose is contemplation time. They keep coming. They come from everywhere. Reply all is possibly the worst thing ever invented in terms of escalating disputes. And the practice tip that I give, every junior lawyer gets it when they start with us, is the 24-hour rule. If you get something that grinds your gears, you tighten up in the stomach, you get angry, park it. Look at it tomorrow. Because the reality is it doesn't need to be dealt with then. And if you stop, calm your farm and think about it, and potentially be the bigger person, because that's not to say that the person emailing you the inflammatory thing is actually right. You will have a lot better reaction the day after. And I know lawyers are great at sending inflammatory emails, particularly to each other. So what happens for me is when I get one of those, particularly if I know it's going to be one of them, I will simply pull it across to the matter where it is, give myself a bring up to look at it tomorrow, and I won't even read it. Because I know it's not going to be mission critical to respond to it. If that's the case, that's great. And I'll look at it tomorrow when I've just calmed. And that, I think, if everyone did in bodies corporate, would prevent a significant percentage of the escalation of the disputes we have, because it's very personal, very quickly, and particularly late at night. And I think talking to Chris's email, we're seeing more and more clients as bodies corporates have the chairperson Higginson Towers at gmail.com. That's their committee email address. They don't get it on their personal address, so they can sit there on their personal email at night and be fine and not get wound up. And if you've got the discipline then not to look at that work email address, that will also calm things down. So those, I think that separate email is really important, but that time, take time. It's usually not mission critical urgent that you respond and fire up straight away.
Yep, would agree, Frank. But a couple of points to bear in mind out of all of that. Put restrictions in place, but remember the body corporate still needs to act reasonably and can't shut down communication if indeed there is a genuine issue. So it's all well and good to put restrictions in place, but still need to actually do something about it if there is a genuine issue. Here's a few more practical tips for you to consider. So these are a bit more advanced, and if things have not gone according to plan already. Hopefully you won't need to actually do any of these, but sometimes you do. Sometimes you do actually have to contact the police, and that's the reality of the situation. The reality of the situation is my office has to contact the police sometimes, and I know sometimes body corporate managers would need to do that too. Bear in mind there's two forms of contacting the police. There's 000, but for far less urgent matters, police link if you go. There is such a thing as a peace and good behaviour order. I'm not going to comment on that other than to say there's a link for the courts for some information about that. And just to plug for a service that is very closely aligned with what my office does and our colleagues in the Department of Justice and Attorney General Dispute Resolution Centres of Queensland. Some of you may or may not be aware of that. This is a service, and it's mostly free, in fact I think it's all free if memory serves me correctly, which resolve the so-called neighbourhood disputes. So disputes about trees and dividing fences, but there's also those so-called personality disputes that they can resolve as well. A few more things that are a bit left field that might help in resolving some disputes. The Anti-Discrimination Commission, I think it's fairly commonplace for my office, and I'm sure it is for Ashley and her team as well, for people to contact and say, I'm being discriminated against. Well and good. If you are really being discriminated against, the Anti-Discrimination Commission is actually the place to go to lodge those complaints. The Office of the Public Guardian is within the Department of Justice and Attorney General, and they have two functions. So they can actually be a guardian for somebody who does not have capacity, but they can also make inquiries on behalf of somebody who is suspected does not have capacity. That actually becomes a bit of an issue in somebody's corporate. It's been an issue in a few cases in my office where it's been apparent that somebody has purportedly signed a document, and it has turned out later on they just did not have capacity to know what they were doing. And one of the other common issues that can sometimes lead to disputes is actually not understanding language. If English is not first language for some people, that's hard enough. If you then try and put into place some body corporate terminology, it actually gets a lot harder. I don't know if you've ever looked at the body corporate legislation, but some of the terms in there really do not lend themselves easily to easy English translation. Sometimes breaking through that language barrier might actually resolve some of the issues in dispute. So this slide here is more about the situation where you actually have to keep going with your disputes. And you've tried all of these steps, you've tried to mitigate dispute is still existing. So here are some best practice tips. This is particularly if you're coming to my office. Narrow the focus. Don't come with a big shopping list of issues that go back 10 years. The point is you want to achieve a particular outcome, so narrow the focus down. What is it that you actually want to achieve on this occasion? And then provide evidence to support that outcome. And as I say, evidence of the situation. One of the examples that I give here is about a barking dog, for example. And the question is asked, I know that the lot owner over there has a barking dog, it's happening all the time, but how do I prove it? Well, you keep a log of it, you record it. There needs to be evidence supplied to the impartial decision maker in the form of an adjudicator to be able to tell what's going on. You need to be able to support your case. Get the timeline right. What's the chronological order of events? And most importantly, why is it being escalated now? Why not before? Be realistic about it. It's reasonably commonplace for people to put in applications to my office where they seek an apology or a public flogging for somebody. While that may be something that is highly desirable for you, it's just not going to happen in this context. There's no capacity for anybody in my office to order or even nicely suggest that an apology is appropriate. Apologies are nice, but you can't make people do them. And I would suggest if you could make people do them, they're not going to be worth anything anyway. So be realistic about what you are actually wanting. And remember, it's an adversarial process. So it's you versus someone else. There will be an outcome at the end of it, so know the respondent being the other party. What is their position likely to be, and how can you respond to that? I'm going to go very quickly over this. I'm not going to go into too much detail. When you launch an application with my office, we need some grounds. Why is it that this is actually happening? What's the situation? There is such a thing in my office as what's called an interim order, and that's an application for injunction, basically. But there needs to be a demonstration about urgency attached with that. There's no point applying for something just because you want it quickly. There has to be something about to happen that you want stopped. If you're lodging an application on behalf of the body corporate or on behalf of the committee, we would need to see the resolution that that has occurred. And pay the fee. That's a big one. Just a word about conciliation then. So my office provides two main dispute resolution services, conciliation and adjudication. Roughly 90–95% of all applications will go to conciliation first. The conciliator drives the process, so it's totally up to the conciliator how things will pan out. There is typically no representation, so we typically don't allow lawyers to be part of that process on either side of the equation. What we try and do is we focus on what's called intake, so rather than actually have to have a conference, we're in the business of trying to solve it before it actually gets there. So our conciliators spend time talking with one party and then the other and trying to actually negotiate a settlement between you. As I said, it's the first step. There are some things that are actually not appropriate for conciliation. So a decision of a general meeting is not appropriate for conciliation. It's not appropriate to conciliate with the entire body corporate. If there's a threat of violence, maybe that is something that we will not conciliate. That said, we do and have conciliated issues where there has been a threat of violence and gotten an outcome. So it's not of itself roadblock. And finally, just a point, there is a legislative requirement that if there is a dispute, that you have exhausted all steps, all reasonable steps to try and resolve it yourself. That's what's called internal dispute resolution. That's quite separate from conciliation. So you need to have exhausted all steps first, then you would attempt conciliation through my office. That is actually a point that sometimes gets lost. So what are the benefits of conciliation, I hear you ask? And it's a reasonable question because people come to my office and they say, no, we want the adjudicator's decision, we want it right now, we just want the umpire to decide. That's fine, but remember, adjudication is an imposed decision on parties, likely to be winner and loser. Conciliation is a lot better because it actually tries to create a better environment moving forward. It tries to actually resolve some of those underlying issues in dispute. So it's quicker and less costly than litigation. There's a greater degree of control that the parties can exercise. There's confidentiality, so there's not a big discussion amongst the body corporate about the issue. It's between the parties. And as I say, it's about harmony. One of the analogies I like to use that in any kind of, say, civil dispute that you have to go to court on, the parties are in dispute, a decision is made, they go away, they don't see each other again usually. Not so in a body corporate. If you have a dispute in the body corporate and it gets resolved, that's great, but you might then see them the next day in the car park, or in the lift, or at a meeting. That's the unique feature of body corporate disputes. The parties in disputes will still have to work with each other and deal with each other eventually. That's why conciliation is the first step, because it's about trying to address those problems moving forward. And we get results. Up to 3/4 of all conciliation matters get an agreement at conciliation. That's a pretty good strike rate, I would venture. Just really quickly, codes of conduct then. There's a few different codes of conduct on the legislation. There is a code of conduct for committee members. There's a code of conduct for body corporate managers. What do the codes achieve, I hear you ask? Well, codes of conduct are very different depending upon how they're structured. Some codes of conduct are legislated, some codes of conduct are voluntary. Codes of conduct largely are aspirational, so these are the things that we would ideally like people to be achieving in their role. Do they have much effect in this context? Well, I'll leave you to judge that for yourself, but Frank has some views.
So Chris, being a public servant, can't express his views. And whatever his views are, or whatever they are, he can't express opinions full stop. I will give you my opinion. He could have added codes of conduct are pointless. So, from our perspective, we get asked lots of questions every day. They're effectively worthless. And usually, if there's issues arising from someone's conduct, there's better ways to deal with it than trying to have a crack at them under any of those codes. End of story. And I suppose the other slight thing I would add from a litigious perspective, completely agree with conciliation trying to be in control of the outcome, because every single piece of litigation has a winner and a loser. And no one in there, on either side, as plaintiff, defendant or applicant, respondent, thinks they're going to lose, but half of them do. So if you can be in control of the outcome in some way by conciliating, then that means that you might have to concede on some things. Knowing what your outcome is better than going in front of a judge, a member of QCAT, or not in front of an adjudicator, but getting something in the mail to say you won or you lost. It's much better having some control over what the decision's going to be as opposed to toss the coin. And as much as I think we do get fairly good outcomes in terms of the Commissioner's office with the ones we run, that's because we tell clients that are going to lose that they're going to lose. But there's lots of people who don't actually get that advice. Because for every winner, there is a loser.
Thanks, Frank. Probably another point to raise about codes of conduct here. Notwithstanding what Frank has said, maybe one of the reasons there are codes of conduct is because it creates this idea that we expect people in a particular role that are exercising a particular degree of responsibility and control to have some idea about those responsibilities. If we take the example of the code of conduct for committee members, a couple of things there. The word committee literally means one who commits, or the act of committing. So the idea that if you are going to be on a committee, you are doing so in the full knowledge that you are ready, willing and able to participate and understand your roles and exercise them correctly. A code of conduct attached to committee members indicates the importance of that role and what's expected in that role. And my office actually supports that with our online training for committee members. Some of you may or may not have done that. It's a free service on our website. You log in, you go through a series of questions. Even if you're not a committee member, it actually is really useful and informative, just as a way of getting some general information. A final point about codes, it's a frequent question to my office that people complain about committee members and say, we want to take action under the Code of Conduct to get rid of them. That's great, but it is, and I think Frank would agree with this, it's a fairly convoluted process to do that. You can actually seek to remove a committee member simply by ordinary resolution without giving any reasons. You don't need to necessarily go through that process. I told you I'd speak fast. That's more or less it. For those of you who don't already have that, I'm sure you've already got that bookmarked or you have that on speed dial. That's my office. That's Frank. Frank is ready, willing and able to take your call at a moment's notice. As are Ashley and their team, I'm sure. I'll leave that up there. We will now whip into questions. So we have a bunch of pre-questions. We have questions via the Slido app. We'll try and run around the room because the second mic isn't working.
So we might just sort of rotate these around. I might drive traffic and throw. First question off Slido, what's happening with smoking laws in Queensland bodies corporates? Answer is absolutely nothing. Recommendations are on the Attorney General's desk. What happens with them, we don't know. Might need to go and ask your local member. Yeah, so nothing. Next question off Slido, which I'll slam through quickly. How is the administrative fee ratio determined to the sinking fund ratio? And I suppose the answer to that is there isn't actually a set ratio. So body corporates are creatures of statute. The Act requires that they raise an administrative funding every year for what the day-to-day spending will be. The Act requires they have a sinking fund forecast, which can be on the back of a beer coaster, but otherwise... and that's actually this week's column in the Sunday Mail, actually, believe that or not. The sinking fund ratio should really cover what the long-term spending for the body corporate is going to be over the next 10 years for, say, painting and lifts and so on and so forth. Those two things are completely independent of each other. The admin fund's basically dependent on what contracts and commitments the body corporate's got day to day. The sinking fund will depend on what the facilities of the scheme are, and they are what they are. So the budgets need to be set according to whatever those requirements actually are.
All right, I'll do a couple of the pre-questions. In an application, and I'll paraphrase all of these so that we can get through them. In an application for conciliation that's failed and adjudication application has been lodged, is there anything preventing the committee from providing all owners a copy of the papers, including the conciliation papers? The answer is no, there isn't, but it's actually a pointless exercise because in adjudication, the application gets circulated to all owners as a matter of course. Anyway, so my office actually instructs that. Typically, what happens is my office sends a notice to somebody like Ashley, and then Ashley or somebody in her office will actually then send that out to all owners in the scheme. Every owner has the opportunity to make a submission if they want. The key word there is invitation. It's not an obligation, it's not a requirement, and indeed there may be some circumstances where it's actually preferable to stay quiet. So it's an invitation only. Next question. What to do if the majority of voting owners won't agree to spend money on maintenance or major repairs at the detriment of the structural integrity of the building? First step is to have a bit of a discussion. If that vote fails, you need to be asking around, did you really understand what you voted for there? That's a form of self-resolution. At the end of the day, if that was a general meeting decision and you've attempted to resolve it that way, it could potentially be challenged through my office, seeking an adjudicator's order to invalidate that particular motion and its outcome. I'll do a few more of these and then hand back to Frank. Frank, who is a member of the committee, was bullied by the site manager because she would not sign a document she considered to be inappropriate. Who can she make a complaint to? Look, it really depends on the circumstances here, but just to clarify, there's no reference to bullying under body corporate legislation. So there's no requirement to not bully, there's no provision about bullying. I don't actually know what bullying means. I know everybody uses and knows what the word is, but there are very different meanings depending upon the circumstances and the context. So it comes back to the slide I had earlier, narrow the focus. If somebody says, I feel bullied, what do you actually mean by that? Was it the way somebody spoke? Was it how they communicated? Was it the words they used? There are various ways and means. If it's physical, if there's actually a physical threat, I would suggest that's a police matter. Frank, did you want to add anything there?
Yeah, no, that's really it. This is back to this human behaviour component. You know, and I suppose the parallel I sometimes have to give clients is, yes, you're in a body corporate, yes, you're tied by a CMS, this BCCM Act and related modules and whatever it might be, but sometimes the parallel is, if you're living in a house and the person was doing that, what would your rights be? So if my next door neighbour's kids are playing noisily on the road, there's nothing I can do about that when I live in my house. And that sometimes, unfortunately, is the reality of the situation you find yourself in as well. Rightly or wrongly, that's just the way it is. So just because you're in a body corporate doesn't mean sometimes you've got any additional special rights around a range of things. So, and probably what I'd add to, in terms of Chris's question there about liabilities, I suppose, and there's a couple of questions on the pre-answer, or the pre-questions that have come in. A body corporate has a statutory obligation to keep, maintain and repair common property and keep it in good condition. So you and I, if we live in a house, can let the gutters fall off, let the basement crack, let the walls fall down. That's our choice as a property owner, but a body corporate, when it's common property, doesn't have that same right. So, and we do get them occasionally where, and I suppose lead into another question that's absolutely there, what happens when our sinking fund's not sufficient? Mentioned before, we've got to have a 10-year forecast. There's absolutely some tightening that could be from a legislative perspective about how that forecast is actually created, but at the moment, like I said, it can be on the back of a beer coaster. If it's not sufficient, and if the body corporate actually doesn't have the money to spend, what can happen is if the body corporate at general meeting chooses not to do it, that's an application in Chris's office to appoint an administrator to strike a special levy and to do the work. We've actually had to do that a couple of times, not for a while to be honest, it's probably 5 years since I did the last one of those, but if the thing's falling down and you as an owner want to make sure it's repaired, that's your process. But again, from an evidence perspective, how much do we need to raise? What's the likelihood of these things needing to be replaced? What's the history of the sinking fund? How much has been raised? How much needs to be raised? All that sort of stuff needs to go into the mix. But a body corporate cannot let the building run down. Well, I'll take the first question from the floor while we're randomly doing it.
I was just interested, can you define what is good condition? Because people have different levels of cleanliness and maintenance, etc.
Completely agree. So that is part of the grade that the lawyers play in. What is good condition? For me, for example, with lifts, I'd say the fact the thing works, it shows up, it doesn't break down every 2 weeks, would be not good condition. The fact that it might break down once every 6 months and then get repaired within 24 hours is still probably good condition. And then you go around the outside of the building. If the paint is flaking and falling off, that's not good condition. If it's faded, that probably still could be good condition in context. And around and about you go. And probably what I find is that it'll be more than one thing. You know what I mean? So it's going to be a range of issues. We have clients come in sometimes with, I've got this particular problem. So, well, I bet you it's more than that. Yes, it is. So you've got to look at the whole of the scheme. So that's the budget thing. I was going to, next two questions on Slido I'll do, then come back to you, Chris. What to do if proper committee formats are not being followed at committee meetings? Here's the joy. There is no committee format in the legislation. So each committee really, within reason, can run its own race in the way it wants to run it. And the people that make those decisions are on committee. And that even comes down to how often they meet. There's nothing in the legislation that says committees need to meet a certain number of times a year, a month, a week. So some bodies corporates go through and run everything on box. Probably more interested ones with people that obviously want to get together. I don't know, actually, what would you say? How often? Quarterly would be the standard?
For the bigger ones.
Bigger ones is...
A lot of the smaller ones here, perhaps don't even meet.
Yeah, so the legislation is interesting in terms of it allows a lot of self-governance inside certain constraints, and how committees run things is really largely up to them. But I suppose back to the question, what if the format's not being followed? For me, the answer probably is if the committee's making decisions that aren't lawful, then that's when they can be held to account in the context of you're spending more than you should, you haven't got the right sinking fund forecast, you're not having a meeting and allowing me to be there. But outside those things, if they're complying with what the legislative constraints are, then they're having their own format, which is probably going to be okay.
Can I just ask a question in relation to that?
Yep.
Does that apply to...
Sorry, just screen for that.
Yeah. just in relation to what you've said, does that apply to, my understanding is that you have to document inward and outward correspondence. So would you say the same thing there, that they can be selective in what correspondence they document?
Yep. So for those of you that don't get my newsletter, please subscribe. I wrote on this a little while ago in terms of committee meetings, what needs to go in. So in terms of documenting correspondence, that's also a bit vague in the sense of even noting in the minutes the fact that something's been received. So it could be letter from the owner of Unit 3, full stop. It could be letter from the owner of Unit 3 and attach it. It could be a summary of the thing. But there's nothing in the Act that says how that needs to be described in the minutes. So that then comes back to each committee in terms of how they're doing what they do. And then the answer to that is if they're not listening to your complaints, you've got the opportunity to communicate with all of the owners. You can get access to the body corporate roll, there's no Privacy Act, you can get access to owners' information. So if the committee's not communicating what you want, you can communicate to owners. And I suppose that's the context of, and I suppose that can be abused in the sense of people firing in diatribes and expecting the committee to circulate that diatribe to everyone for the minutes is what that's trying to avoid. So you do have your own means to get out to people.
Thanks, Frank. A few more questions here, and then I'll come back up. Sorry, no, we've got one up here. This will get my step count up.
I have a question about maybe decisions being made outside of the committee. What's the appropriate way for decisions to be made? If you've got a committee, but the decisions are being made outside of that committee, is that appropriate? What is the requirement? And, so in other words, if there are no meetings being held, the decisions are being made outside of the committee by some committee members, I think that's not appropriate.
I think so. Frank, do you want to kick that off?
Laurel and Hardy. So my answer to that question is that it absolutely happens where committees get together and make decisions informally and then tell Ashley what they are. That's what they can do. So, and I suppose what they say about politics is we get the people we vote for. That's what happens in a body corporate context as well. So they don't necessarily just have to sit there. There was a newsletter I wrote 1,000 years ago about Clayton's committee meetings where it was sort of frowned on, in a sense. I think there was an adjudication about committees running everything in camera, for what a better phrase, where they weren't having meetings. But they can do it by VOC, and your rights really are whether those decisions are still correct and lawful based on whatever the statutory requirements are. So if they're not going to be accountable and they want to hide, then they're going to be able to do it. And that's the reality of the situation. I had clients yesterday who are two of six committee members, and they're saying to me, we get outvoted every time. I said, well, that's going to continue to happen. That's it, your 2 votes. But there's nothing that can happen at committee level, really, that's going to affect in a major way, ideally, your rights as an owner in the body corporate, because most of those things are restricted issues which need general meeting approval, 21 days notice to all owners and all those sorts of things. But if the committee's there, the committee's there. If they choose to run it that way, again, back in the context of that self-regulation, they can. And then what I'll say is, for deep and meaningful questions, we'll all line up afterwards. So if you've got a longer one, happily do that afterwards. I have 2 of my team here as well. Francis, where are you? Yeah. Sorry. And Toddy? Cool. Francis is actually a bit of a hybrid. She's actually worked in the Commissioner's office and QCAT, and now has come to the dark side of private practice. So she's got a unique insight into all of this.
Thanks, Frank. A couple of pre-questions. Someone from Retirement Villages has raised some concerns about sinking fund and motions to increase fees being defeated as too expensive, and has asked, is there a compliance officer attached to my office? No, there's not. There's no body corporate police, there's no enforcement. It's all about self-management and self-regulation. So in the instance where, and we've talked about it a bit today, in the instance where things are occurring within the body corporate that either you think are not appropriate or not lawful or not reasonable, there is a process to challenge those things, but there is no compliance undertaken by my office, no. Next question, what is required to comply with fire safety legislation for a block built in 1970? You need to ask Queensland Emergency Fire Services, that one, I think. Not really something that I could advise upon there. A couple of questions about payments made to committee members for attending meetings. And the answer is under the standard module. Sorry. There it is. Under the standard module, section 43, $50 per meeting, to a maximum of $300 in a 12-month period. That's as of right, if you want to put it in those terms. After that, it becomes a restricted issue for the committee and needs to be decided by ordinary resolution.
At general meeting.
At general meeting. Thank you, Frank.
Yeah.
Another point I would make about that. We've talked a lot about committees. There's obviously a lot of strong feelings about committees, pro and con. We've talked about committee members doing their job. We've talked about committee members not doing their job. A point I would make to everybody is that being on a committee is actually a thankless job in a lot of cases. It's also a volunteer position, notwithstanding what I've just said about payments. If somebody is putting their hand up to be part of the committee and is willing to take that job on, then that should be supported, surely. First point. Second point, the issue about payment. It really depends. One of the other points to think about is who are you actually having do that work for you. If one of your committee members just so happens to be the ex-CEO of BHP, it's probably okay to meet some of their telephone calls, for argument's sake. The point I suppose I'm trying to make is every situation is different. Take that into account. The legislation prescribes the minimum, or in this case, the maximum. Then think about it after that. As Frank said, decision then for a general meeting to make after that. A couple more questions and I might hand back to Frank. My complex has been managed for 27 years. Buildings are now quite old and needed maintenance with very little in the sinking fund. Why was the body corporate not audited to comply? There is a statutory requirement at each general meeting for the question of an audit to be considered. It's actually framed as a double negative. And so if you want the audit, you actually have to vote no in order to mean yes. In this case. But it is a decision of the general meeting. It's supposed to be considered at each AGM, so every year the question of the audit should come up. I think the question is more or less asking is why haven't people voted to audit? Well, that's a really good question. The only answer I can come up with is that they thought it was going to cost money and they didn't want to do that. But it is a statutory requirement that each year at general meeting the question of the audit be considered.